Dan Cotter, thanks for joining us on the Illinois Channel.
Thank you, Terry, for having me. It's a pleasure.
Congratulations on your first book, which concerns the United States Supreme Court and the 17 Chief Justices that have served on that court throughout its history. The court began in the wake of the U.S. Constitution in 1789. Why did you write this book?
Terry, that's an excellent question. And the reason I wrote this book is because in our government, we have three co-equal branches of government, but the U.S. Supreme Court and the judiciary is probably the least understood and the least accessible to the public. And so I really, when I was in law school in sense, have wanted to tell the story and the history of the Supreme Court and the United States through the Supreme Court. And I also have more than 300 books on my shelves at home, and my wife told me I needed to do something with them and hopefully get rid of them. So I'm not sure that I'll do that, but that's kind of a secondary goal of this book.
When you started writing the book, did you focus on any particular aspect? In other words, I would say that the court's interpretation of what the Constitution means varies within the context of the times as the court sits. We have the famous example of, I think it's Chief Justice Taney in the Dred Scott case, and how he said, no, blacks are property. We certainly wouldn't be having that decision made now. To what extent, when we look at the Constitution and we look at the court as the final arbitrator of what the law is through their interpretive process, to what extent does the context of the times control the interpretation of what the Constitution means?
Terry, that's an excellent question. And over time, it's kind of ebbed and flowed in terms of how the court, how close it aligns itself with the times. And as you mentioned, Roger Taney, who followed John Marshall in his Dred Scott decision, was really at the time trying to quiet the nation about the issues of the dispute over the territories and new states that were added in terms of slavery and whether that issue would be resolved. Taney at the time thought that he was putting that to rest. As you mentioned, though, we won't be talking about that today, but at the time, it wasn't an ill-received decision, at least in some parts of the nation, but it has been seen to kind of precipitate and lead to the Civil War eventually a few years later. Some justices are better than that, kind of having that long-term legacy in view in other times. And one of the things we're seeing today with Chief Justice Roberts, for example, is that many were disappointed with his decision with the Affordable Care Act a few years ago when he cited and thought that that was still constitutional. And he's done that in a couple of instances. And so there's some school of thought that he is, in fact, trying to do what you have asked about, is to make sure that the court is aligned with its times and that it's keeping pace and not being too revolutionary or evolutionary.
You know, I remember a couple of chapters in the history of the U.S. Supreme Court to me stand out. One was during FDR's, I guess, first term or so, when he was trying to pass any number of programs and they kept being ruled unconstitutional. And then we had what was alleged to be FDR's plan to pack the court. And then we had a change in one of the justices and the so-called switch in time that saved 9. And then later in the 1950s, and in the context of you're just talking about the court and its times, we had the Warren Court, and Chief Justice Earl Warren, who had been the former Republican governor of California, in fact ran for vice president with Tom Dewey in 1948. But he became rather liberal in the eyes of many Republicans. And so it seemed for a period of time that the U.S. Supreme Court, often then called the Warren Court, was out of sync with its times. And I suppose the question is, as you look at that history, what are we to make, and to what extent, when a court somewhat gets maybe out over its skis, gets ahead of itself, or possibly behind the times, as arguably in FDR's case, To what extent do we see the respect for the rule of law or the respect for the authority of the court wane? And have we seen in the aftermath, I know this is a long question, in the aftermath of that, have we seen a reaction to where then whoever's elected tries to fix that part of the court being maybe out of sync with the general political process?
That's an excellent question, Terry, and we do see some of that at times. The Earl Warren Court, as you mentioned, was seen by some as a judicial activist court, and at the same time, many of the decisions that the Warren Court decided, both in personal liberties and rights and with respect to criminal defense rights, they've withstood the test of time. And I write about that in the book. When Earl Warren was leaving the court in 1969, replaced by Chief Justice Warren Burger, the expectation of President Richard Nixon was that the court would overturn some of those decisions. And in some cases, the court in the last 50 years has done that. But in many other instances, some of the cases still stand. And in fact, it was not the Warren Court, but it was the Burger Court that ruled on Roe v. Wade in 1974. And so a lot of people align that with Earl Warren. But it does happen where the court, after it's, like you said, ahead of its skis or decides things that may be ahead of its time, there is some reaction and some kind of pulling back of the decisions, and that happens. But what I talk about in the book is that when William Rehnquist became Chief Justice, replacing Warren Burger, again, the expectation was that he would be a revolutionary court. That did not necessarily happen, except in some criminal defense rights cases. And now in the Chief Justice Roberts Court, the jury's still out about whether or not he'll be an evolutionary justice or more revolutionary, with the caveat that Chief Justices don't have any more impact than any other justice on the court by law or by statute.
Which is a question I wanted to ask. What is the role of the Chief Justice, and what authority do they have that the other justices do not have?
So in the book, I used the reference of Orwell, and all animals are created equal, but some are more equal than others. The Chief Justice by statute and by the Constitution has no difference of role or function. But what the Chief Justice can do, and often has done, and we see it again some with Chief Justice John Roberts, is try to get a sense of that pulse of the society, get a pulse of where the needs are, what needs to be done, and try to, through intellectual force and through camaraderie and through reasoning, try to move the court. You mentioned earlier Charles Evans Hughes and the switch in time that saved 9 in the court packing plan of FDR. And what happened there in many instances was coincidental, or at the same time that FDR and the legislature was considering court packing plans, Owen Roberts, as you mentioned, for whatever reason, mostly through discussions with Charles Evans Hughes as the Chief Justice, started to take a second look at some of those cases and some of FDR's New Deal and turn his vote around, saving the court for 9. And so that happens. But the Chief Justice, the only place that the word Chief Justice is even used in the Constitution is in impeachment hearings for the President of the United States. Chief Justice of the Supreme Court shall preside. And that's the only place it's listed. And the Judiciary Acts that have come out since 1789 and been amended, there's, again, no mention of specific duties or enhanced powers that the Chief Justice has.
You know, former Governor Rauner, once referring to the Illinois Supreme Court, referred to them as politicians in robes. Now, the judges or the justices of the Illinois Supreme Court, unlike the US Supreme Court, are elected, so they're arguably, one could say that. To what extent at the US Supreme Court, where the justices are appointed, to what extent is politics practiced on the court? And to what extent do you find that in a review of the history of the court, the justices put their politics aside and try to be affirming the law as written?
Terry, that's another great question. And the reality is that a lot of people, other than Governor Rauner and the Illinois Supreme Court, have talked about that at the federal Supreme Court. The reality, though, is up until recent times, you could not necessarily tell how a decision was going to come down by the party that appointed the justices that sat on the Supreme Court. And a good example of that is in 1991, 8 Republican appointed justices were on the Supreme Court, and yet a lot of the decisions from 1991 until recently still upheld some of the rights that, as you'd mentioned, were found to exist in the 1950s and 60s under the Earl Warren Court or the Burger Court. So in terms of the politics, that hasn't necessarily been at play. I do write about in the book that the amount of money that's in politics that's in the Supreme Court today. One of the things that I write about in the opening and in the close and concerns about is the fact that $20 million was spent on the last three nominations to the Supreme Court. That's just when you have that kind of money, that's dark money. We don't know who gave the money. We don't know what kind of influence that has. That's troubling. And we're starting to see Senator Sheldon Whitehouse has been writing a lot about the 5-4 decisions that have included 5 Republicans in the last 13 years under the Roberts Court and concerns about that. So I think we're starting to see the politics in the Supreme Court level that we haven't seen in the past. In fact, I was visiting last week at my alma mater, Monmouth College, and one of the communications directors down there mentioned the fact that in the mid-'80s, he stayed at his friend's house who was in law school, had a constitutional law book on the shelf, and he took it down and started to mark down which justices were on which decision, and he said there was no pattern. And so we really don't see a huge pattern until recent times. And finally, a final note on that is that, again, when we look to 1974 and Roe v. Wade, it was a 7-2 decision. 5 of the justices in the majority, believe it or not, were Republican appointed.
In fact, I think it was Harry Blackmun who was appointed by Richard Nixon, wasn't it, that I think penned the decision of Roe v. Wade?
He did. Very slowly, but he penned it.
As you have reviewed the court and as you have been a practicing attorney, we can say that you are one of the past presidents of the Chicago Bar. Are there any justices that stand out in your mind, or the 17 that you think are really great examples of what a justice of the court should be?
That's a great question. And in the back of the book, in one of my appendices, I rank the justices, chief justices, with the caveat that it's impossible to really do that effectively. Chief Justice Roberts is not in there. The top 3, and again, just because of their force of intellect, their force of ability to come to consensus on the court, are John Marshall, who served for 34 years, the longest by far of any of the justices that were chiefs. And then Earl Warren and Charles Evans Hughes are the other top 3, and Bill Rehnquist is number 4. When you look at each of those individuals, they each have the ability to, again, modify and moderate courts that were not necessarily on the same page, that had some personalities that were very difficult. For example, Charles Evans Hughes had Felix Frankfurter. From all intents and purposes and all reporting, he could be very difficult. He would try to take people under his wings in the first month or two of their newness, and then when they refused to follow along lockstep, he would start to make fun of them and make comments about their judicial abilities or inabilities. So those are the top 4, just again because of their ability to kind of shape the court and get it to have at least a semi-semblance of consensus and direction of the court.
I had a chance to interview Mary Ann McMurrow, the first woman to serve on the Illinois Supreme Court and first one to be Chief Justice. As she was retiring, I asked her, if the law is the law, what difference does it make if you're a woman? And she said, I'm glad you asked that. It makes no difference. The law is the law. I'm not sure a lot of people would agree with that. Maybe some would agree, some wouldn't agree. But in your estimation, we look back on the US Supreme Court, it was approximately 35 or 36 years ago that Sandra Day O'Connor was appointed by Ronald Reagan to become the first woman on the court. no woman has yet served as Chief Justice. But in your estimation, to answer my question, what difference does it make? And now we have several women on the US Supreme Court. What difference does it make that women, or blacks for that matter, are on the court in your estimation? If the law is written, speak to the demographics of the justices.
Sure. First, Justice Mary McMurrow was just a legendary person. I met her and interviewed with her, and she was a great role model in Chicago. To your point of whether or not it matters persons of color or women on the Supreme Court, the short answer is no, because again, they're all intellectually talented. They all have the best interests of the nation in mind. But what it does, and what I think is the importance and why having Sandra Day O'Connor in 1981 and 3 justices on the court today, is it reflects the demographics of the nation that exists today. And that's important because people do come from different perspectives in terms of gender and race and just religion as well. And that's one area probably where the court is probably the most non-diverse today, is with respect to religion. 4 or 5 are Catholics right now, 3 are Jewish, and then Gorsuch, I believe, is evangelical. He was Catholic though. And so we don't have a diversity of religion on the court. But again, you're right. The law is the law. They should be interpreting the law and applying the law as it is. The challenge, of course, is that whether you're an originalist or a living constitutionalist or some other judicial philosophy, the Constitution of the United States is a little tiny 5,000-word document, and so it doesn't have all of the situations and all of the happenings and all of the words defined. And so again, there's now on the court a battle of dictionaries, and which dictionary was the proper dictionary for a certain word. So each of the chambers has their own dictionary from 1700s or 1800s, depending on the amendment or the provision. So that would be my answer, is that again, people bring different perspectives, but the bottom line is that everybody should be coming at it from the same approach.
Before we close out, and I'm sure given my interest, I could talk to you for an hour, but we won't do that, but appreciate your time. What do you make of the court now? I mean, it's fairly balanced. I think we get, as you mentioned earlier, a whole lot of 5-4 decisions. I think those on the left side of the perspective are worried about Ruth Bader Ginsburg and her health, and whether President Trump will have a third appointment to the court, which is, he's already had 2 in his first term, and in fact just in about his first 2 years, which is, I think, it's rather unusual, but maybe not, it's not unheard of. But I know Jimmy Carter in 4 years never had a chance to appoint anyone to the court. There was not a vacancy. But talk to, if you would, one of the things too is, I remember 20 years after John F. Kennedy was in his grave, he still had his Supreme Court Justice Byron White on the court. And so when a president can appoint someone to the court, it really extends the legacy of their presidency, does it not?
It does, and that's one thing, regardless of what people positions are on President Donald Trump. I've written about it pretty extensively. One area where he's got a legacy that will last for many years, as you said, is on the courts. Right now, he's got 22% of the Supreme Court, he has over 20% of the courts of appeal confirmations, and with the nuclear option that was invoked a few weeks ago, he will now have 20 to 30% of the district court nominations and confirmed judges at that level. And so that's, when you look at the history of the courts in our country, that's a pretty phenomenal legacy. And many of them are very young. Gorsuch and Kavanaugh are both in their early 50s. They could be on the court for a very long time. Chief Justice Roberts is 65 years old, so he could technically still be on the court for another 20 years. And so that is where they hit the legacy. And like you said, long after JFK was dead, Byron White was still in the Supreme Court. Brennan served for many years, an Eisenhower pick. And so when you start to look at that, that is in fact where presidents have a legacy, regardless of what they do in their 4 years or 8 years or however long they've served.
I remember when you talk about after Earl Warren, you had Warren Burger become the Chief Justice. Richard Nixon appointed him. He was a pretty conservative justice. But he started a tradition, and I don't even know if it's still being conducted, but he would give the State of the Judiciary, just as the President gives the State of the Union address. In fact, I'm from St. Louis. I was in grade school, and he came to Powell Hall in St. Louis to give the first State of the Judiciary back around 1969 or 70. Is that still conducted, and is that something that you think is a good idea, just in passing? I don't know if you mentioned that aspect in your book.
I talked some about Warren Burger. He was pretty influential. There's question about whether or not his court really moved the needle at all or a lot. But in terms of the Supreme Court Historical Society, in terms of what you're talking about, the state of the Supreme Court, that is, I believe, still done. They appear before Congress each year, and Chief Justice Robertson does that. I do think that's healthy, and it's also in writing. To talk about the challenges facing the courts, the finances for the courts, some of the decisions that come down from the courts, and just the health of our judiciary. It is, after all, a co-equal third branch of the government, and yet, both in Illinois and at the federal level, the amount of funding, the amount of attention that's drawn and paid attention to the courts is probably not as significant as to the executive and legislative branches.
Let me, on that, I'm glad you brought that up, because let's just depart a little bit from the actual theme of your book on the 17 Chief Justices. But given your knowledge of the judicial system, I, as a layman, have often wondered to what extent we need to restructure the finances that you just touched on, that especially in Illinois, where you have counties funding court operations. And some of the counties in Illinois, we have 102 counties, there's quite a number of them that are impoverished or really struggling. They're agricultural areas. They don't have commercial properties to be taxing. And we had a case I mentioned in one of my interviews with the Illinois Chief Justice. We had a case several years ago where a family of 5 or so were killed in Lincoln, Illinois. And the trial, that one trial, virtually bankrupted the county as far as the cost of putting that on. And it made me wonder, we as laymen just think, we, part and parcel of our taxes is to keep the judicial branch funded. But when you lift the hood and look under that, often the financing of the court is almost in a crisis mode, and several of the Chief Justices, Justice at the Illinois Supreme Court level, Justice Kilbride, among others, and others, have brought that up and tried to say to the legislature, we're a co-equal branch of government. We're not asking for a full third, but we need more money. Can you talk to what you know about that, and to what extent is that a real concern?
Terry, that's a huge concern. I know in the state of Illinois, and Kilbride and Carmeyer and other justices that I've talked to, and just being involved in the Chicago Bar and the American Bar Association, I think the percentage of funding of the overall budget for Illinois is about 1% goes to the judiciary in the state of Illinois. And so, like you said, they're not asking for a third, but 1% is very difficult to fund and operate the court systems in 102 counties of Illinois. The other challenge is that for many people, the cost of going to court is overwhelming and substantial. And I'll give you a good example. Is my dad gave my son his car. It's a 2002 Windstar. The auto dealer is out of business, but he's still on the lien, still on the title. And so I had to spend $500 in the Court of Chancery in Cook County, and I'm still don't have the title transferred because we haven't been to court yet. But $500 for the court filing and for serving the state of Illinois to do something that should be free or low cost. And so that's what happens, is that there has to be funds to run the courts. And if it's not funded through, like you said, taxpayers think they're paying for that, as well as the other parts of our government, it has to come from somewhere. And it's a real problem because, like you said, a court like in Lincoln, Illinois, and has a jury trial and it almost bankrupts the system, justice is not going to be available to the average person.
Dan Cotter, we already took you a little longer than I initially intended to. We appreciate your time and your thoughts, especially on some of these Illinois issues. Maybe we can revisit with you and get your insights into the court system, because as I say, I'm a layman. I haven't been in there, but you're going to know where some of the injuries are within the system that maybe need to be addressed. And I think in this kind of coverage, it's also helpful to educate the lawmakers as well. A lot of times they can't be conversant on everything, and they can address an issue once it's brought to their attention. So maybe that's something we can do. For those, however, who are interested in your book, want to know more about the Chief Justices of the U.S., where can they find your book?
My book's available on Amazon.com. You can type in the Chief Justices, and it should show up in my name. And thank you, Terry, for having me on the show.
We appreciate your time, and good luck to you in the book, and hopefully we'll visit with you again in the near future.
I'd love to be back on. Thank you.
Thank you.